the facts that Don just gave you are so important for you to understand the refugee resettlement problem. It reminds me of a quote from Thomas Jefferson: "You can't be ignorant and free at the same time. It never was and never will be." So it's important for everyone to understand these figures so that you can place them in context of what is going on in the legal issue that I'm representing. First of all, some days are diamonds, some days are cold. Yesterday morning, I was sitting at the airport ready to fly into D.C., and all at once I get a email on my phone saying the federal judge just issued an order on the Refugee Resettlement Act that you filed, and they dismissed the case. It was like, I'm coming here to discuss my case, and they've dismissed it. Now, it's a 43-page opinion that took the judge 6 months to apparently draft and research and draft. And I feel that I would be doing a disservice not only to the court, but also to my clients until I really have a good understanding of what this judge was trying to do. And of course, I think it's filled with appealable issues. The judge basically backed off because it was too controversial and ruled on the basis of standing of the legislature to bring the lawsuit and standing of some very courageous individual legislators who put their name in the lawsuit as well. It reminds me of the tale of two legislatures. On the one hand, you have the General Assembly of Tennessee taking a strong stand, believing that the government is wrong, and yet not violating the rule that the government has set. They go into court through the due process aspects of the case and make a case that this government is violating the 10th Amendment and the Spendings Clause. On the other hand, you have the tale of the California legislature who says, I don't give a damn what the federal government says, and they go ahead and violate whatever rules that they feel they can get away with. One thing to keep in mind, the General Assembly of Tennessee has an obligation to balance the budget every year, unlike the federal government. So the legislature has that. The legislature is in control of the budget. An accurate way of describing what is going on here in the refugee resettlement area, it's that the federal government is the ventriloquist and the states are the puppets. Whatever the federal government says, you have to follow or you're going to face horrendous reaction. One of the ways that we figured that the federal, that we could get into court and muzzle the ventriloquist was by a lawsuit using the advice that Chief Justice John Roberts gave in the Independent Federation of Business versus Sebelius, where he said, quote, "The states are separate and independent sovereigns. Sometimes they have to act like it." Okay. We took that advice. Tennessee is a part of the federal government, the federal system, but it is also considered a sovereign. That was the case that we relied upon in bringing our case into the federal district court, saying the federal government is impinging upon the sovereign rights of the state of Tennessee. I want to give you a real-life context of what this really means. There was an article in a Tennessee paper a few years back in 2011, and the headline in this article was, "Faith Matters. Catholic Charities Helps Somali Woman's Family Transition Out of Chaos." And they have this woman and 11 children, all minors, okay? And the story goes that 8 of those 11 children were now getting prepared to go into public school system. And they, you know, and the Catholic Charities that was responsible, you know, took some pride in getting these people ready for school and becoming Americans. In the shadows, in the background, while we were presenting this picture, there were 7,000 disabled children waiting to get a special treatment in the welfare program because these children wanted to stay home with their families and friends, although the federal government and the state gave them money as far as welfare goes. These programs that the children and the families wanted to get into were not mandatory programs. So based upon the obligation of the legislature to make sure they followed the Medicaid rules, they didn't take care of these 7,000 disabled children. They focused their attention because they could lose about $7 billion of state aid that the federal government was giving. They focused on what they had to do to keep that $7 billion. And as Don said, unlike most immigrants, refugees don't have to make a showing of self-sufficiency when they enter the country. When they come into the country, they're automatically able to get on the welfare rolls, get on Medicaid. So at one point, Tennessee, when it first started out, was voluntarily involved with the Medicaid program. But as Don has also explained, that at one point, the federal government, like it does a lot of times, slowly backed out of federal funds and pretty soon laid the onus of taking care of these refugees on the state. And the state bill kept on getting larger and larger. One of the problems is it is so large we don't even know what it is because we can't keep track of all the benefits that these refugees get. For instance, the 11 children, they're going to have translators. They're going to have English language training. When they get into court, they have to have a translator, and it goes on and on and on. And it's very difficult to track those things. So when the reimbursements ended and the state of Tennessee had to take on more and more burdens, they decided that they were going to pull out. They did pull out in 2008. They thought they pulled out in 2008. The refugees still kept coming in, and the state taxpayers still had to foot the bill. And there was this question about if we stop supporting the refugees coming in, we are threatened with a loss of 20% of our state budget, $7 billion. And that's important because if you lose $7 billion, 20% of your budget, the case that I discussed earlier, or mentioned earlier, the Sebelius case, they said if you're threatened with losing 10% of your budget, that you are no longer voluntarily getting involved with the refugee program. It's coercion. It's a gun to the head. Okay, it is not a voluntary situation any longer. I have to make a few things clear. The lawsuit that we filed in the U.S. District Court, the Western District of Tennessee, had as its sole aim to get the federal government to say, what are the rights of the state of Tennessee vis-a-vis the federal government? The lawsuit was not intended to harm immigrants. It just challenged the ability of the federal government to force Tennessee to pay for something they didn't want to pay. They were being forced to pay for a federal program with the federal government telling them what they had to do with state taxpayer money. And there are several cases on that, but it basically involved the 10th Amendment, and it also involved the spending clause, because the courts have said the federal government can encourage states to do certain things. Okay, for instance, if they want to increase the age of alcohol, the federal government can give states some money if they do raise the age of alcohol consumption. But that's a slight nudge. They talked about, I think, the South Dakota case where it was only like 1/2 of 1% of the total budget that the federal government gave, and they said that can't be coercion, but 10% can. There's two cases I want to discuss. One was the Prince case. It's a 1997 case where the Supreme Court struck down a federal law that mandated, as an interim basis, local law enforcement agencies to conduct the background investigation for the Brady Bill. So they said, okay, we're going to have this regulatory system where we're going to control people that can get guns, handguns. But they placed the onus of doing that on sheriff's departments and other chief law enforcement officers of the state. So several law enforcement officers, chief law enforcement officers in counties sued the federal government. It was the Prince case, Prince versus United States. The Supreme Court struck down that portion of the federal law, and it said that by forcing state governments to absorb the financial burden of implementing a federal regulatory program, members of Congress can take credit for solving problems without having to ask their constituents to pay the solution with higher taxes. And that's one of the things that is happening in the Refugee Resettlement Program. As they pulled back, as Congress pulled back the reimbursement, they still could take credit for handling the Refugee Resettlement Program, but it was the state of Tennessee taxpayers that were being burdened by this new regulation. Justice Scalia wrote the opinion in the Prince case, and just a couple of quotes. The state legislatures are not subject to federal direction. The federal government may not compel the states to enact or administer a federal regulatory program. That's what Justice Scalia said. The other case was the case of the Independent Federation of Businesses versus Sebelius. In that case, the amount of money that the states would lose if they didn't go along with the federal government was about 10%. And they said permitting the federal government to force the states to implement a federal program would threaten the political accountability key to our federal system. The threatened loss of 10% of a state's overall budgets is economic dragooning that leaves the states with no real option but to acquiesce in a Medicaid expansion. Congress may not simply conscript state agencies into a national bureaucratic army. So in the Sebelius case, they said 10% was dragooning, was coercion. In the case of Tennessee, we have 20% of their budget, their total budget, that could be lost, threatened, if they didn't go along with the federal government. And this judge basically said the only way Tennessee can really have standing to sue, which was the basis of it, is for Tennessee to violate the law, which creates all kinds of issues that I don't think this judge really thought about. You violate the law. Just think what the ACL will do with the number of lawsuits that will then be filed on behalf of refugees, because there's also federal law that says you can't discriminate. If someone's in your state and you give benefits to a certain class of people, you can't discriminate against the other. So in conclusion, I just want to say the Supreme Court's case of the NFIB, the National Federation of Independent Businesses versus Sebelius, squarely governs the case here. Unlike the federal government, the state of Tennessee must balance its budget. By this lawsuit, Tennessee is displaying constitutional responsibility to be a prudent steward of the state's tax dollars and the welfare of all of its citizens. Thank you.